coffee break. I hope you were all inspired by Senator Dallaire's comments. I know every time I hear him speak, I am. So we're actually officially starting the thematic sessions with the first one on international law and the Genocide Convention. And I'd like to give the chance to one of my colleagues, Adrian, who's been busy for the past 5 months helping make plan this training program we started last January. Adrian came on board to help us. He's an international student at Concordia, just finished his BA in political science, and a citizen of France. So we're kind of like a small United Nations here at MAKE. So without further ado, I'll pass on to Adrian.
Good morning, everyone. Well, first of all, I'd like to thank you all for being here today. It's really a pleasure to have you among our team and for this program. Thank you also to Robert Dallaire, who gave a very instructive discussion and presentation. So I'll just be briefly introducing Professor René Provost. So René Provost is an associate professor at McGill University. He holds a Bachelor of Laws from the University of Montreal and a Bachelor of and a Master of Law also from the University of California at Berkeley. I just got confirmation actually that he was Naomi Kiko's professor at McGill, so that's interesting information. He also holds a DPhil from the University of Oxford. He served as a law clerk to the Justice Claire Leroux-Dubé at the Supreme Court of Canada in 1988-1989, and also taught international law at the Lehigh University of Pennsylvania in 1991. Well, to move on to the more concrete stuff, so from 2005 to 2010, he was the founding director of the McGill Center for Human Rights and Legal Pluralism. He taught international public law, international human rights law, and international humanitarian law legal theory. He's the author of the International Human Rights and Humanitarian Law. He also wrote Mapping the Boundaries of Belonging Between Religious Revival and Post-Multiculturalism, among others, many different articles and books. And finally, he was the president of the Société Québécoise de Droit International from 2002 to 2006. So please welcome Professor René Provost.
Merci beaucoup, Adrien, and it's a pleasure to be here to participate in this event of what is in effect a sister institution for us at the McGill Center for Human Rights and Legal Pluralism. As a Provost, I was kicked out from being the director of the McGill Center because McGill, like Concordia, doesn't allow us to just keep going for extended periods of time and forces regime changes once in a while. But Frank has contributed many times to events organized at McGill, and so it's a pleasure to be here to engage with you in a discussion about genocide and international law. Looking at the program, my sense is that this is one session that is specifically devoted to legal dimensions of this issue. Although at least Naomi Kikola is a trained lawyer, and there may be other presenters who happen to be lawyers as well. I wanted to ask, actually, who amongst you is trained as a lawyer? Raise your hand if you are. Okay, so about 6 people snuck into the room. So I'm going to talk about law. And hopefully I will speak about law in ways that avoid formulations which only the 6 people who have legal training will understand. And if I lose myself and use shortcuts that lawyers use to refer to complicated ideas without actually having to explain them, do please interrupt me. In general, I think it would be most congenial to have more of a conversation than a straightforward presentation or lecture on my part. However, it takes two to tango in that sense. So if you interrupt me, I'll be happy to have a conversation. If you don't interrupt me, I'll be happy to just keep talking. But I will therefore invite you to raise your hand and ask questions or offer comments. Maybe in relation to what I've just said, you have personal experience or can relate it to another issue, something that you've experienced that we can discuss, and I think it would be more interesting for everyone in the room, judging from the really interesting conversations that just happened in the break. And we don't want necessarily the highlights of the conference to be the breaks in between the panel presentations. So I was asked to talk about genocide in international law, the Genocide Convention in international law. And I think the interest in looking at that is that the law offers a narrative of the idea of genocide over, let's say, a century, more or less, which is not necessarily a narrative that is more accurate than the narrative that historians or political scientists or anthropologists might have to offer. But it is a narrative that probably captures the way in which governing elites have viewed genocide over the last 100 years. Because who controls the means by which international law is produced? Fundamentally, they're controlled by governments. So this is the government's idea of the concept of narratives, and it will be full of ambiguities, but perhaps to some extent less full of hubris than some other narratives that seek to move people and perhaps simplify some other issues that genocide tends to be related to. So it's one narrative. I think it's useful to have it in front of you to use as part of the way you think about genocide. But there is no claim to the dominance of that narrative beyond the realm of law. You can think about law and probably international law all the more so as a kind of anti-Twitter. Twitter is the on-the-moment reaction in very, very few words to an event. And Twitter is informative in that it tells you kind of the instant reaction of a diverse group of people about any given issue. International law, on the contrary, is resistant to any kind of rapid reaction to an event. It speaks to the long trend in the way in which the international community will consider a phenomenon like genocide. And so it is in that sense that it is useful. It is meant to offer guidance in ways that will alert decision makers to long-term interests and the sustainable construction of an issue like genocide away from the knee-jerk reaction that tends to happen, which again isn't any less legitimate, but it just speaks to two different ways of looking at a issue. So I thought about what is there to say as a lawyer about genocide. And I came up with 6 ideas. So why and how did the provision of genocide emerge in international law, IL, and be used for international law throughout? Second, the legal concept of genocide, what it is that we mean to refer to in international law when we talk about genocide. Who is the victim? This might be a funny thing to ask, but as I'll try to suggest to you, the answer isn't necessarily very obvious, at least for lawyers. We tend to see things in more complicated ways than ordinary people. The answer isn't necessarily obvious. Likewise, who is the perpetrator Well, there's a variety of people who intervene in genocide or genocidal activities, and we want to ask, does law consider all of them in similar ways? And the answer is going to be no. Who can do anything about it? I was speaking to two R2P enthusiasts at the break that you will hear from more later, but there's R2P and there are other ways in asking that question, who can do anything about it? And finally, what must be done? Okay, so six questions, 45 minutes or so, depending whether we keep to the appointed schedule. If you ask questions, we might jumble all these six issues and speak about them in ways that really don't have anything to do with this kind of linear presentation that's on the PowerPoint, and that would be probably better. But let me start at the beginning. Why and how did the prohibition of genocide emerge in international law? I think it's important at the outset to be conscious of how new this whole thing is and how not far in the past you have to go to find a complete empty space as far as the regulation of the way in which governments treated their own population and to some extent other people's population, but more than not their own population. And there are three phases that we can differentiate in that respect. So pre-Nuremberg, the Nuremberg, the Holocaust / Nuremberg as the emergence of legal regulation of genocide, and finally the adoption of the Genocide Convention. So the pre-Nuremberg, if we basically go all the way to the middle of the Second World War, really governments could do pretty much whatever they wanted to their own population as far as international law was concerned. I mean, this is the story of the emergence of international law as a whole, as a regime. And a significant part of that is the emergence of a regime to regulate armed conflict, which is really was a core part that states agreed to regulate first, and then other parts grew around it. And so if we look at the First World War, there were norms there that had been agreed upon by states, legal norms, as to the way in which you treated particular categories of individuals, especially, or in general, these were, the relationship that was regulated is one that crossed the line of hostilities. So the way in which you treated enemy prisoners of war most clearly became regulated. So you couldn't do what had been done during the U.S. Civil War, for example, because states had agreed on specific rules. How you treated enemy civilians, well, already that was less obviously, clearly regulated. But there were nevertheless some norms applicable. How you treated your own population, well, we can probably safely say that there was no international legal standard that restrained a state's ability to do what it wanted, including physical eradication of any part of its own civilian population. And we could mention, the Belgian regime in the Congo. For those of you who are familiar with King Leopold's Ghost, a book that really, I think, in the starkest way revealed the extent of atrocities committed by Belgian authorities in Congo in the late 19th century, and obviously the Armenian genocide during the Second World War, about which there's this famous quip from Adolf Hitler, who asked in 1939, who remembers the Armenians, to say that no one was going to care about what Germany did to its own Jewish population, and Roma and gays and communists and all the other people that the Nazis didn't like. We can see, and then you can ask, why is that? Why would you regulate how you treat POWs, prisoners of war, but not care about tens of thousands, if not hundreds of thousands, of people being persecuted and including physically eliminated? And there is a certain conspiracy of silence at that time, whereby every government agrees to the need to protect the sanctity of state sovereignty. And General Dallaire was talking to us a moment ago about how R2P is a challenge to the supremacy or the dominance of the idea of state sovereignty. And this is a process that has been progressively going on for the last 100 years. But certainly pre-Nuremberg, there was very little that challenged the absoluteness of state sovereignty. So, a conspiracy of silence, every government agreed that it was in their own best interest not to bind themselves in that way, and not to invite other governments to intrude into what was going on in their own territory in relation to their own population. So in the 1930s, there were, not that many, but there were some comments by governments about the way in which Germany was treating its Jewish minorities, but these were not couched in legal terms. You might think this doesn't make a big difference. If you're a lawyer, you pretty much have to buy into the idea that, well, having a legal norm as opposed to not having a legal norm makes a difference. People can differ about that, but certainly there was no legal norm. During the Second World War, the Allies decided that there was a need to prosecute the Nazi leadership. And this was agreed at a conference in London relatively early in the war, where I think most fundamentally the four major powers of the time, the US, the USSR, England, and France, they were the big fours that were there at that point, wanted to punish Germany for starting another war. That was the big point that they sought to make. Next to that, there was mistreatment of prisoners of war, which was also felt to be an accepted standard by that point in international law, and might as well punish them for that too. And then next to that were what was called crimes against humanity, in that initial conceptualization. And crimes against humanity was, they were pulling the cover to include things that were not clearly provided for under international law at the time. And this was the way that it was written into the charter of the International Military Tribunal system in Nuremberg, where there were three categories of crimes: crimes against peace, or going to war crimes against essentially prisoners of war and enemy civilian population, and crimes against humanity, which would cover basically the way that Germany treated its own population. You have to say that in that respect, it's quite clear that there was no legal foundation to convict anyone at that point. What the German members of the High Command and a few, the 17 accused, I think, in Nuremberg, something like that, what they did was not a crime at the moment that they had done it, quite clearly so. So there was clearly a kind of a retroactive application of criminal standards to these individuals, from which a few people shed tears, but nevertheless from a legal standpoint.
Just a point of information, is that also the same mandate at the tribunal in Japan?
Yes, so there was an international military tribunal for the Far East created. That's the formal name. The crimes there was the same taxonomy. We don't tend to talk about the Far East Tribunal, the Tokyo Tribunal, because it is even more objectionable than the Nuremberg Tribunal. It was basically an American creation rather than a more multilateral process. They cared even less about issues like due process, validating evidence, whether the rule existed or not. So it was a more overtly political mechanism than Nuremberg, which was a tainted judicial process, but nevertheless, I think more legitimate in sufficient ways that it created a legacy that was a foundation in international law for what came after. So a number of individuals were convicted in Nuremberg for crimes against humanity, and essentially what they were convicted for is what we call today genocide. And it's a little bit confusing because we also have something today called crimes against humanity. And it grew out of that, and it all grew out of the idea of crimes against humanity in Nuremberg. The last thing I would mention is that at Nuremberg, there was a requirement of a connection between, let's call them genocidal activities on the one hand and war on the other. So that the International Tribunal could only convict Germans of participating in genocidal activities, labeled crimes against humanity, if they occurred in a manner related to an armed conflict. Now, why is that? Well, this is the legal way of putting the cover, but not so blatantly or so obviously that you have a harder time defending yourself. So essentially, it's to make it kind of a subset of war crimes, which obviously relate to war. And that's why at Nuremberg you have this necessary link to war for crimes against humanity. It's because it was kind of an extension of the idea of war crimes as applied to Germany's own population, which hadn't been protected up to then. Otherwise, let me just mention for the last bit of the pre-Nuremberg that there were treaties on the protection of national minorities adopted at the end of the First World War, because the mistreatment of minorities had been considered as one of the root causes of the First World War. And so there were treaties, a series of bilateral treaties between Poland and Germany, for example, had a treaty whereby the Poles agreed to protect Germans living in what was then Poland, or what became Poland, and vice versa. This didn't necessarily translate into some kind of human rights, because some of the things they did pursuant to those treaties were exchanging minorities. So they forcibly displaced, as we would say, I give you 25,000 of mine and you send 25,000 of yours, and then we'll be happier for it. This is what we describe today as ethnic cleansing, but this is what governments thought was a good solution to avoid future tensions that might trigger warfare. And so security was the driving concern in creating these standards in that period. So we get to the Genocide Convention as basically taking the lessons from the Second World War and from the Nuremberg trial. And I mentioned in passing there was one trial of the the International Military Tribunal at Nuremberg. And then after that, there were a few hundred trials run by the Allies, including a number in Nuremberg, but by American military tribunals sitting in Nuremberg. But it's not the same as the International Military Tribunal. And then there were tens of thousands of trials run by German courts in occupied Germany. And all of these later trials also included prosecutions for crimes against humanity, what we call today genocide. So you shouldn't think that only a handful of individuals were convicted after the Second World War for what we now call genocide. In fact, there were many, many people convicted for that. So genocide appears with the Genocide Convention. And I mentioned Raphael Lemkin here as an important individual he was a Polish emigrated to the United States, a law professor, who wrote a book in which he basically invented that word, genocide. And it became nearly instantly used to describe German persecution of its Jewish population generally. And we don't, the word genocide is used nowhere in the charter of the Nuremberg Tribunal or in the judgment. So it's not there, but when in 1949, 3 years later, when we have a treaty, it becomes the label that is preferred to identify genocide. And what the Genocide Convention seeks to do is fundamentally to create an obligation for states not to do what Germany did. So it is a convention on the prevention and repression of the crime of genocide. So each government binds itself to prevent and repress, prosecute, punish the crime of genocide on its own territory. We're a far cry from responsibility to protect yet at that stage, in the sense that it really is a duty that states undertake towards themselves, most fundamentally, and in a collective sense, in a much looser fashion. And if another state, for example, were to engage in genocidal activity, what can another state party do isn't very, very clear under the Genocide Convention. So it's important to realize that the Genocide Convention is a first step. It's an important first step, but it's a very incomplete document when viewed from 2013. But it does embody a clear statement of never again by the international community. The Genocide Convention today has 142 state parties. There are, I forgot to check, but there's something like 192 parties to the United Nations. It keeps going. That isn't a particularly high number. When you compare it to, the Convention on the Rights of the Child is ratified by everybody by Somalia and the United States for different reasons. One doesn't have a government, and the other has a dysfunctional government. But nobody objects to the substance of it. Even the Covenant on Civil and Political Rights has much more state parties, many more, I suppose. The Geneva Convention is ratified by, I think, 196 states, more than you might charge. So compared to that, 142 actually isn't a lot. So if you come to it thinking, there's a consensus that genocide is a crime, everybody agrees with that. It's true in some sense, and less true when you look in other places. And one of those places is who has ratified the Genocide, the Convention on the Repression genocide. And if you look at who hasn't ratified, well, there's a map if you Google it, and there are big parts of Africa that are not covered by that convention, including major players like Nigeria, Angola, Kenya, which are not party. These are politically significant states. There are other countries like Thailand, Indonesia, which are also not members. Japan has not ratified the Convention against Genocide. The United States ratified it only in 1988. So there are big holes in participation, which, it's explained in a variety of ways. And one explanation, which is interesting, is that everybody agrees so much that genocide is prohibited under international law that nobody wants to invest the political capital needed at the domestic level to ratify. And this is one explanation that's given about Japan, for example, where it just never makes it to the top of the list of the government's priorities. And so it's just like, yes, that's one explanation, but there are parallel and competing explanations, including about Japan, which don't necessarily support that picture, and we don't necessarily know which is. So we got now an idea of genocide embodied in the Genocide Convention. So what is genocide? Well, I put on the board Article 2 of the Genocide Convention, which defines genocide as acts committed with intent to destroy in whole or in part a national, ethnical, racial, or religious group as such, and then a list of ways in which you can intend to destroy in whole or in part one of those groups. So a few things that can be said about this definition. So we cover only national, ethnical, racial, or religious group. And one thing you can ask is, what's not there? Do you cover with this every group that might be subject to genocide, or that has been the subject of genocide in the past, or subject to something that maybe we should call genocide in the past? And we pretty quickly get to instances of mass executions of the grandest scale, which are difficult to fit into this definition. And I think that perhaps the clearest instance is the Cambodian genocide carried out by the Khmer Rouge, which wasn't carried out on ethnical, racial, or religious grounds, but it's difficult to rationalize that particular episode, but I guess ideological would be the closest that we get to that. The famines engineered by Stalin in the 1930s, or the purges, which, basically anybody who was so unlucky as to be in the wrong place at the wrong time, or said anything to anybody who mattered, got targeted by these measures. So these wouldn't be genocide. Even in Rwanda, it was awkward to quantify the Tutsis as either ethnical, racial, or religious group. The word religious, but racial, that's furthest from what was there. Ethnical, well, that there's a whole debate, as you may know. as to the reality of the difference between Hutus and Tutsis. And when the International Criminal Tribunal for Rwanda was, was presented with an indictment for genocide and had to apply the standard, then it had to decide. In order to convict someone with decades in jail, it's a very, very rigorous requirement that you demonstrate that they did exactly what is defined as the crime. Because if you don't, in criminal law, if you don't fall precisely within the crime, then you're off. You're allowed to do everything that you're not prohibited from doing. But the problem was that the ICTR was loath to endorse the kind of colonial invention of the Hutus and the Tutsis, or as many people argue that is where this distinction comes from, and that in fact there is no such ethnic distinction that can be demonstrated. That's the legal standard. So the ICTR kind of fudged it, and they whatever. So we see that this is problematic in that respect. What's not there? What category can you think of that ought to be there, that could be there?
Political groups?
Yeah, political opinions, right? And interesting, in earlier epochs it was there, but the story of how it came not to be there is not necessarily very, very clear. Fingers point to the Soviet Union as wanting to avoid, persecuting reactionaries under Stalin. But when you think of the extent to which communists were persecuted by Nazi Germany, sent to extermination camps, it's a little surprising that it's not there. And certainly when you think about mass atrocities, well, one of the ways in which you identify a massive group is on political ground. Right, so gender isn't there. And this is, again, another really interesting idea. And, I mean, we talk about, if you read kind of feminist critique of international law, you see sometimes endorsement of the idea of a gender apartheid, which says, there is a systemic exclusion of women and limits as to what they could do, which reminds us of the apartheid system. I've actually never seen the idea of a gender genocide in the sense of targeting a gender. Let's imagine that it would be women, for example, or if you think in gender categories beyond male, female, then targeting transsexuals, bisexuals, people who do not wish to identify themselves with one gender or another, then yeah, you might say this is a form of genocide. The selective abortion in places like China and India, if it were related to a policy, could be identified as that.
And systemic rape, where would you do that?
This is typically viewed as a way of intending to destroy a group defined on racial, ethnical, or religious grounds. And this is the way it was characterized in former Yugoslavia, for example. So the systematic rape of Muslims viewed as, destroying that community, but not as such an assault on women as the identified group.
Going back to the gender issue, in Guatemala, women were murdered because they didn't convert to future communism. So 35% of the victims.
Right. Right. But this is a parallel to the Yugoslavia in the sense that you're targeting their political group as opposed to targeting women as the group, which is not, it's not impossible to imagine, but I don't know any example. Certainly, sexual orientation is another one that isn't there as opposed to gender, which, again, given the scale of persecution of homosexuals during the Second World War by Nazi Germany, the extermination of homosexuals, you could wonder why isn't it there? And we know why it isn't there, because there's no government in 1945 that care too much about what happens to homosexuals, or that care to put themselves out in defense of homosexuality. So, political explanation is obvious, but viewed from where we stand today, we're stuck with that treaty. And this speaks to what I described earlier as this kind of long-term narrative of the international community about genocide and how difficult it is to make it evolve. And these other categories are making their ways into the definition of genocide, largely through the work of the ICTY, the Yugoslavia Tribunal, and the International Tribunal for Rwanda, which really have made international law jump ahead from where it stood in 1949. And between 1949 and 1993, the creation of the ICTY, there was very, very little evolution in the legal regulation of genocide. And then after 1993, both in the jurisprudence of these tribunals that were created and in the statute of the International Criminal Court, which codified a significant number of these changes, then we see a movement. As far as means are concerned, so you see the list of how it is that you intend to destroy in whole or in part one of these groups. One mean that isn't there is cultural genocide. And this was something that was very much debated in 1949. And it was listed in one earlier draft of the convention that became the Convention Against Genocide. But it was taken out, what this alludes to is the destruction of a group by prohibiting the use of a language that is associated with a group. In this country, we have an example, the very president of Montreal, about residential schools with Aboriginal children being punished physically for speaking native languages with a view that they would become good citizens, francophones to somewhat lesser extent. But this is one way that will be present in many places, prohibiting songs and so on and so forth that are ways through which culture is transmitted. And this is an issue, I think, most burning in relation to Tibet and the Chinese attempt to sinify Tibet as much as possible, both by way of transfer of population and by the stifling of Tibetan culture. And so they're not, as far as we know, really putting people in concentration camps and exterminating them. But it seems to display an intent to destroy the group so that they wouldn't be within a few generations. Yes.
So you alluded to this in your example on Cambodia, but I'm curious as to how the North Korean situation would be interpreted by this definition. I guess it's sort of under the control of the profit being based.
Yeah. I don't think there's a genocide in North Korea. And it's, I mean, this is the danger of genocide in the sense that there's a certain tendency to make it all genocide. And it speaks to the last point, the power of naming. And it's, let me flip it around and mention the extreme reticence of the U.S. government in 1993 and even in 1994 to use the word genocide in relation to Rwanda. And you know, when we knew what was going on in 1994 in Rwanda, and we all knew that this was not a small-scale event. But anybody remember what really people were thinking about in 1994 in the United States? No. Yes. Monica Lewinsky. That was the important issue. And you know, how do you define sexual relations and whatever? So, yeah. So, the United States was, you know, you could say A, it didn't care that much. And B, to the extent that it cared, it was extraordinarily reluctant to use the word genocide or to support the use of the word genocide in something like a UN Security Council resolution. Another example is the use of the word genocide by Colin Powell when he was Secretary of State in describing the events in Darfur. And this was an extraordinary event because of the reason that I just explained in relation to Rwanda. It's because all of a sudden, the United States formally called something genocide. And then, never again. Not genocide, but never again did they call it genocide. In the sense that they immediately started retreating from that label. Why? Why care about it so much? Well, we care about it so much because of the stigma of the Holocaust. And this idea, we always go back to this phrase of Edmund Burke, all it takes for evil to triumph is for good men to do nothing. And this is, or Elie Wiesel, after the Second World War, who said, the great tragedy of the Holocaust is not all the death in the concentration camp, but rather all those who stood by and did nothing. And in some ways, the post-World War II international community remains traumatized by that to some extent. And the Genocide Convention is a reaction to that. But it's a reaction that is, we didn't necessarily put all our money where our mouth is. Because if you consider the UN system, for example, well, in 1945, when the UN system was being created, there was a debate as to what kind of a regime was this going to be. Was this going to react to? And there were two tendencies. And one was basically kind of a human rights kind of regime. And the other was a collective security regime. And, you know, I'll give you two guesses to know which one won the day. The mention of human rights in the UN Charter is minimal, extremely vague and general reference to human rights. Whereas the whole system is built on collective security. And the Security Council system, with the asymmetrical powers granted to the superpowers of the day, all of that is meant to control international security and not obviously deal with situations like genocide. And we'll come back a little bit to exception.
Sorry, go ahead. I was wondering how this definition of genocide should apply to the issue currently taking place in Burma. I see that, to me, all of them, except the bottom one, number E, partly it is also there taking place. And, but the international community in complete denial of the word using genocide, what is taking place against Rohingya as well as the Muslim in Burma.
Yes, absolutely. Well, thank you for mentioning that, because for many, many years, I'm a pretty cynical guy. I do research on Google, so it's company territory. But to be honest, Burma is an outrage, and I remain angry about the international community's complete carelessness about the situation in Burma that has been going on for decades. And there, I think you have to render to Caesar what belongs to him. The United States has been actually more vocal than pretty much anybody else for a long, long time on Burma. And I think that we can make a perfectly reasonable claim that there has been a genocide in Burma. Campaigns of systematic rape of women on an ethnic basis in Burma have been going on, forced labor, disappearances, and so on and so forth. And the international community has really not done anything. We see somewhat of an evolution in this respect, and my own uninformed, really, impression is that I'm very skeptical as to the evolution that is going on today, and whether the policy of opening that is led by the United States today is wise. But certainly what we do see is that this process of increasing relations with Burma as it does loosen some things is certainly not accompanied by any language of accountability for what has been done over years and years and years against its occupation. And there are superpowers with vested interest. There's one superpower with vested interest that makes it unlikely that this will happen. We will get a Security Council refer to the ICC about Burma. So it isn't as if this is all old history, and it is still happening today. I did want to go back to North Korea, just to say that there are, massive and systematic violations of human rights in North Korea today, but probably not genocide. And we have to be careful in how we wield this idea of genocide. And the ICTR, in one of its judgments, called genocide the crime of crimes. And it speaks to a certain hierarchy in amongst international crimes, so that genocide is at the apex. There is nothing worse than genocide. And then you get crimes against humanity, and then you get war crimes. And then there's language to that effect in the ICTR case law. But it's hard to sustain that claim. It's hard to sustain the idea that the crimes against humanity that went on in Sierra Leone were somehow less bad than the genocide in Rwanda. There is an incommensurability to the horrors that makes it extremely difficult to sustain that kind of legal then there were debates in the office of the prosecutor as to whether they ought to charge people with genocide. And some members of the prosecution were saying, you know, this isn't the Holocaust. And then, yeah, obviously, you know, but okay, so, you know, the Germans or Nazis killed 6 million people, and they didn't kill anywhere near that in the former Yugoslavia. Is genocide just that? Is genocide just one event? Never again in that way will we characterize it. And there was an internal debate, and after a while, it was thought, no. It is a phenomenon that is broader than the Holocaust and cannot be deferred simply by referring to that historical moment. And so we expanded it. But nevertheless, the idea is to seek to reserve it to extreme situations. And lawyers will say, well, situations that meet that criteria. But you see slippage constantly in popular language as to, you know, genocide here, genocide there. And it is something that I think is people ought to feel awkward. You know, it's like a tsunami of shopping opportunities. There is an obscenity to the way in which we use these words, but nevertheless they use them.
How would this apply to the Syrian context now? I mean, looking at this, I mean, I can see that A to E, almost like all of them apply to what is happening in Syria. There is a systematic destruction of part of the society carried out by another part. Yet it's not national or ethical or racial or religious, although there is a sectarian element to it now, like more recently. Is it genocide? How would you categorize it?
Yeah. It's generally not thought of as a genocide. And for the reason that you mentioned, is that there is destruction and killing on a very, very significant scale, but not necessarily a policy that is rooted in the targeting of a group so defined. And in a way, you know, it goes back to the idea of, you know, do we need a hierarchy? Is it really, so are we going to say they're just war crimes? Because then, you know, there's armed conflict ongoing, and certainly, for example, if you target civilians, this is a war crime. Is it less bad, less evil to do that than to do it as part of a systematic policy to target a particular religious group or ethnic minority? With genocide as a legal concept, the international community has said there is something specifically horrible about the targeting of a group that we want to capture. But so we want to capture that reality, but it isn't to say that it is worse than war crimes, or crimes against humanity. So the answer then, with respect to Syria, would be certainly the use of gases in urban areas would be a war crime, indiscriminate targeting of civilian population. Possibly crimes against humanity if it's done on a sufficiently massive scale, which may well be the case in Syria, but probably not genocide. And this, you know, it speaks to this other point that I had, that who is the victim? And in a way, the name said it all at Nuremberg, crimes against humanity. And it was thought that humanity was the victim, rather than the individual members of the targeted group, which explains why, up until the adoption of the ICC statute, not much attention was paid to victims of genocide in international law. They were witnesses, possibly, but that was pretty much it. Because it was thought that humanity as a whole was the victim, and that all of us are injured when some of us are targeted on a religious, ethnical, or racial basis. And we see with the ICC statute, there is an attempt to make more space for victim, and this is part of a new kind of evolution in international criminal law, paying more attention to victims, and an attempt to work victims into the way in which international law treats genocide, reacts to genocide. But we see that with respect to Uganda at the ICC, it creates very, very significant tensions within a process that is defined or constructed around the need to determine the guilt or innocence of the accused. And the criminal process, whether nationally or internationally, tells one story. And it tells the story of the accused. And it tells the story of whether the accused is guilty or not guilty. The criminal process does not tell the story of the accused. And there was always a tension within international criminal law in seeking to create a record. This is what they sought to do at Nuremberg, and even more at the ICTY and ICTR, which is why you get judgments that are hundreds of pages long, detailing all the events that occurred everywhere on which there were testimony to forestall denial. Because every Holocaust or every genocide had deniers. So there's a will to create a record, but this isn't the story of the victims. It's a record. With the appearance of the victims at the ICC, then victims represented through lawyers, then there is a tension, and it's not clear whether it's actually all going to work to fit victims into a criminal process at the ICC. It's happening right now, and there are lots of problems with that argument. Yes?
Just to fast forward, so if someday, hypothetically, we did decide that some episode of violence did fit into genocide, do you think that part of the problem is that if states did somehow intervene, that a sustained conflict would cause all the wind to take out of this movement? Or do you think that by us intervening would create this precedence of intervention in the future? Because we're waiting for this marquee episode where the international community does actually act. What do you think could unravel from this event?
Well, this again goes back to international law as an anti-treaty, a long-term narrative that evolves progressively. And there is there's too solid a foundation to these norms for them to be challenged seriously by any kind of events such as you described. What might happen is that the mechanisms to implement those norms might be fragilized and might become dysfunctional. And that is less unlikely. We are now still 15 years after the creation of the ICC, very much still in the construction phase of the ICC. And it's, the ICC has relatively little political capital at this point, and desperately has little resources. Whatever expensive the thing is to run. And so it's proceeding very, very cautiously to build its credibility with cases that seem to be suitable for a successful successful prosecution. Now there is a paradox. It's not the scenario that you envisage, where the international community intervenes and doesn't go well, and then what is the impact. Rather, and perhaps more unpredictably, the cautious approach by the ICC has led it to intervene mostly in Africa, because that's where there are more conflict than elsewhere. And and so the ICC is active today only in Africa, or has active cases, I should say, only in Africa. And this has triggered a backlash centered in the African Union and fueled, let's not be naive about it, by people like al-Bashir and the Kenyan government and a few others that weren't necessarily the greatest fans of the ICC process, Rwandan government, and even the Ugandan government. It's not necessarily happy with its decision to turn to the ICC. So there has been a backlash in the African Union against the ICC in particular and the international criminal law regime in general. And this is a very bad thing because the ICC has invested everything in Africa, basically. And it's in its hope for successful prosecution. And if there is a widening movement of non-cooperation within African governments, then the ICC will be effectively prevented from completing its cases. And it will be demonstrated quite clearly how weak the mechanism is to implement international crime, including genocide. And I mean, al-Bashir is indicted for genocide in Darfur, and doesn't seem to have slowed him down too much in his international travels, even outside of Africa. And there are a whole range of issues about diplomatic immunities and heads of states, which we talk about. It's quite technical, but it's actually legally complex and not necessarily clear. So I think that the danger lies more there than in some eventual, dramatic intervention by the international community. We take over Burma, and then we can prosecute whoever we want, and then it doesn't take over.
So is it that? I need to understand why the use of the word genocide is such a big deal. Okay, so is it because it triggers some kind of obligation on the part of the international community that the international community is unwilling or unable to face? Or, well, let's see.
Okay, so this is the part where we get to argue. And we'll have to close soon to lunch. So what happens when you say it's genocide? Well, let's take the example of Darfur, because it's one example where they did say it's genocide. As opposed to the other times that they want to say that. So what happened? Well, okay, definitely nothing much happened. And so if you look at who can do what, well, if you focus on international organizations, so what happened to in Darfur after there was this label of genocide? The Security Council referred the situation in Darfur to the International Criminal Court. Now, that was something. And so I exaggerate when I say nothing happened. A little thing happened. So they referred the case to the ICC, which was the only way the ICC could be seized, because it hadn't ratified. the statute of the International Criminal Court. But two things. Sudan is not cooperating. And in a way, this is an example that shows how difficult it is to use international criminal law in relation to a state that doesn't want to cooperate at all. And this was actually the only instance of that. Even Rwanda, which hasn't always had the best relations with the ICTR, certainly is not non-cooperating in that way. So the investigators of the ICC can't actually reach the place of the crime. They can't excavate, find the bodies. This is what prosecutions are built on. And if you can't do that, all you can do is speak to refugees in Chad that have fled. And this is not bad evidence, but very limited evidence. And when you're a prosecutor, it's very hard to build a case on only on evidence just like that, and satellite pictures that show that people moved next to that village on that day, and just when 5,000 people disappeared, yeah, you need to go dig. If you don't dig, you don't get a conviction. So that's one aspect. The second aspect of this ICC referral by the Security Council is that, well, many people view it as a way for the United States and all the other Security Council members to say, okay, we did our part, now the prosecutor is going to bring justice. And it was a convenient kind of thing for hiding the international community's complete inaction with respect to genocide in Darfur. And so it's kind of a convenient excuse not to do anything else. So that's for intergovernmental organizations like the UN. Are governments required to do something? So the US says, oh, there's genocide in Darfur. Does it have to do anything? Well, you'll hear about R2P in a moment, so I won't go in detail into that. But there isn't really much to the chagrin of the French government and Bernard Kouchner. It's famous droit ou devoir d'ingérence. There really isn't a duty to intervene on the part of an individual state. Possibly, you could stretch it to a right to intervene, but you have to be an optimistic international lawyer to think that it's an established law. Maybe he will be an optimistic international lawyer. Otherwise, there's something like out dedere, out judicare. Now, I'll give you a hint. Whenever you speak to a lawyer and they start speaking Latin, you know that they're not sure how solid their argument is. And international lawyers speak a lot of Latin. And so out dedere, out judicare is either you give or you judge. So it's a duty to either prosecute yourself, individuals on their own territory, or to extradite them to someone who wants to prosecute them, whether it be an international tribunal or another country willing to prosecute them. Few countries do any such thing. Canada, that righteous country amongst the nations, we've convicted one person of genocide, Désiré Munyandesa. We've sent back Leon Mugesera to Rwanda for him to be prosecuted locally. And there are one or two others that are in the pipelines. But really, if you look at state practice to see, do states actually do this? Well, there's Judge Garçon in Spain when he was kicked out of office, and Belgium before they changed the law. Really, states don't do it. So what does it mean? It doesn't mean much. What is the real impact? And I'll close on that just lunch. I think the real impact is with civil society and with kind of a popular outrage that can move these other actors to act in some cases. But it's very, very hard to create a kind of coalition that will successfully move to act. You know, think about Darfur, which has got to be one of the broader coalition to move to do something. I mean, I'll say, if George Clooney can get us to do something, you know, what hope is there for Burma that nobody talks about, or, you know, Equatorial Guinea or Gabon, where there are also massive and systematic violations of human rights that have been going on for decades. And I dare you to tell me when's the last time you've heard of these two countries. So it's a bit of a depressing picture. When you move from, you know, is there a norm? Yes, and what does it cover? And it's not perfect. To legally speaking, you know, what's our leverage? And this is where governments have been extraordinarily reluctant to recognize for themselves a duty to do anything. So that conspiracy to protect state sovereignty that I evoked when I talked about, you know, the Armenian genocide and the First World War, well, it certainly hasn't disappeared completely, and it certainly hasn't been shattered by timid emergence of the responsibility to protect. Thank you very much.
I want to thank you, René, on behalf of MIGS for such a detailed presentation on international law and the slow but consistent evolution of it. You'll see that we immediately follow this. We're going to move to lunch now, have about an hour to network and talk to each other. Then we'll have a panel on the responsibility to protect, which is clearly the political mechanism which all states have agreed to actually enforce international law. So I just want to say thank you and look forward to talking to you in more detail in the next few minutes.